So it has been an intense and fascinating afternoon. We are now ready to open the discussion of our final panel. Thank you so much for all the participants that are still with us. Again, as we are recording the session, I have to repeat for the third time the brief note on GDPR for our panelists. Your participation in today's session entails your implicit consent to the publication of the video and audio recording, as well as extras of it, on websites, online platforms, and social networks used by the research project or by third parties with whom we've established a partnership. So I'm now delighted to give the floor again to our special advisor, Professor Diane Ring, who is Associate Dean of Faculty, Interim Dean, and Professor of Law at Boston College Law School. She will be the chair of our final panel, The Solutions. Building upon the phenomenological and theoretical issues identified during the discussion of the first two panels, our panelists will consider the measures currently in place to address the main issues that have been raised, assessing their strengths and weaknesses before considering what improvements could be made. Diane, the floor is yours. Thank you so much.
Thank you, and delighted that we're now able to kind of turn to this last set of questions. I might say that solutions is an ambitious goal for us, but certainly thinking about directions, I think we could definitely offer that. I'd first like to introduce our panel, and so I'll start. I have Linda Galler, and she is Professor of Law at the Maurice A. Dean School of Law at Hofstra University. She specializes in sort of ethics and tax practice. She's the lead author of the Regulation of Tax Practice, and she has chaired the Standards of Tax Practice Committee of the ABA tax section. Next, we have Jonathan Goldsmith, a solicitor and a member of the Council of Law Society. And from 2001 to 2015, he was Secretary General of the Council of Bars and Law Societies of Europe. And that represents over 1 million European lawyers through its member bars and law societies. Next, we have Henry Grzes. He's a CPA, and he is part of the tax practice and ethics team within the tax division of the AICPA, and that's the American Institute of Certified Public Accountants. And among his many duties, he is part of the, or sort of leading the task force that's looking at revising the standards for tax services. And so a very relevant topic. Next, we have Paul Scott. He is a former trial attorney with the civil fraud section of the U.S. Department of Justice. And now in private practice, he represents whistleblowers with claims under the False Claims Act, Vehicle Safety Act, as well as whistleblower programs through the IRS, the SEC, and the CFTC, and continues to work with the U.S. Senate and the executive branch on these programs. Next, we have Frederica Wilson. She is Executive Director and the Deputy CEO of the Federation of Law Societies of Canada, and she manages the Federation's work on public policy issues, and those include those related to professional responsibility, lawyer mobility, and anti-money laundering. And related to the latter, she co-chairs the Federation Government of Canada Working Group on Money Laundering and Terrorist Financing. And closing out our panel, we have Simone Zancani, a lawyer and also Vice President of the Criminal Law Association of Venice. He's also continues his studies in criminal law and writes regularly in that area, particularly with the focus on the European Union in criminal law. So I'm just thrilled to welcome our panel. The way I thought we would proceed, sort of, I see the vision for what we're going to be talking about here is trying to think about what are those paths to improvement if we're trying to increase detection of the conduct that we don't want to see, increase success in prosecution, and prevent, right, the facilitation of those activities we don't want to happen at all. But to get us started, I thought I'd open it up for each of our panelists just to offer 3 minutes sort of max, just your own reflections on what we've heard so far, sort of as we're brought from the first to the second panel to hear what you would just sort of like to sort of offer as your initial remarks. So I'll just go back in order of my my introduction. And so Linda, I will start with you.
Thank you, Diane. Thank you for inviting me to participate in this wonderful program. I have 4 observations, which I'm going to make very quickly. And if anybody's interested in talking about them a little more later, we can. And if not, we'll just let them go by. One is the discussion in the last panel was very interesting to me, but I did want to just point out that I think there really is a significant difference between ethics and professional regulation. It seems to me that professional regulation should, in a perfect world, reflect what we as a group consider ethical behavior, but they aren't necessarily the same thing. And so I think that one of the things that we ought to be thinking about in this space, if I can use that trendy word, is focusing on professional regulation rather than appealing to individuals' personal sense of ethics, because we're going to find people all over the place in that regard. And what really counts, I think, I'd like to make people better people. I'd like everyone to be more ethical people. But I think if there are guidelines that people ought to follow or ought to aspire to follow, that's kind of where we go. And I think in the United States, if you look, there are virtually no reported instances of professional discipline of lawyers in tax practice. And so I think that it's a very under-regulated area, and that is one place where I think there may be some room for improvement. That said, my second point is that I think there really are differences between and among the various professions that we talked about today and groups of people that we talked about today. And I'm being protective, I know, of my own profession, but I think it is very dangerous to march down a path that ends up as having lawyers as gatekeepers, to use a word that was used earlier today. And I think pretty important in that context is the lawyer's duty of confidentiality. And I think the reason for that is I think that people really do need to come to lawyers and spill the beans and tell them what's going on. And if there's any hope for a lawyer advising a client to do the right thing, and I say that both as a legal matter and as an ethical matter, which a lawyer should be doing, there needs to be some trust in the relationship. And I think that's in the background here, and that's something that ought to think about. My third point, sort of, something that I think it was Charlie mentioned, and it was some discussion we talked about earlier, was this notion of adverse consequences to whistleblowers, that you can't get another job, that you lose your job. And interestingly, I sort of went back as I'm sitting at my desk here. I wrote a very short essay about this exact issue in the context of the US model rules 9 years ago. It was published. And basically what I said there was I looked at the rules that govern US lawyers, which basically say that if you see a problem, you should go up, we call it up the ladder. You should report it up the chain in the corporation to the highest levels. And if you get to the highest levels and you see that there isn't resolution, and I'm really very simplifying this, there isn't resolution, then consistent with the rules that otherwise govern duty of confidentiality, you can disclose that. But the problem is, there are a couple of problems I pointed out. One is that all of these rules are not only subject to various kinds of technical requirements that I won't get into, but they're not mandatory. It's the choice of the lawyer. And it seems to me that given reported cases, and we're hearing some more of them today, the risks are pretty darn big to a lawyer who decides to effectively blow the whistle on his or her own client. And so I think that the deck is stacked away from doing that. That said, I'm not sure that a lawyer can, in virtually any situation in the United States, blow a whistle on his or her own client because of the duties of confidentiality. If you learn something in a confidential relationship, I don't see there being very much wiggle room. There's some, and that's outside of my 3 minutes, so I won't talk about it, but there's not much room to breach that duty of confidentiality for what might be considered personal financial gain, or for public gain for that matter. And then finally, I just wanted to mention, Josh talked a little bit about thinking about, how will a tax case play for a jury? It's very complicated. And without questioning that, because I've never been a prosecutor and I certainly can see the issue there, I will say that I think statistically in the United States, the number of law students or the percentage of law students that take tax during their law school career has been diminishing very significantly over the years that I've been teaching tax law. So I think of tax as being part of the basic literacy of being a lawyer, even if you never practice tax law. I think, as I tell my students, tax touches everything. But oddly, that message doesn't seem to be getting through to lawyers either. And I'll leave it at that.
Thank you. And I can mirror your reflections on declining, enrollments talking to colleagues across the country. Jonathan, next.
Thank you. Thank you. I'm grateful that the last speaker has started to talk about the difference between lawyers and the others who've been mentioned today, because I have been distressed by how lawyers have been gathered in with accountants and others as if they're just one big group of professional enablers. She has mentioned one aspect of why lawyers are different, and I will mention others. Obviously, lawyers are structurally different. There's a huge problem with accountants, with the Big Four and how they're structured. They're very, very differently regulated internationally as opposed to lawyers. But some of the issues which come out from lawyers, again, tax avoidance, tax evasion was all, sometimes people separated them out, sometimes people didn't. Tax evasion, we're all agreed, lawyers are agreed. There's no protection in regulation. We want them out. It's a crime. Tax avoidance, very different is lawful. And I raise it because it also raises different ethical issues, because ethics have been raised again and again, and ethics which apply to lawyers, because tax avoidance is lawful. And it raises other ethical issues which have not been raised. Everyone has a right to representation. Are we saying that people who want to avoid tax lawfully have no right to representation? It also raises the issue of lawyers being identified with their client's interests. Are we saying that because a client wants to do something lawful, which is to avoid, the lawyer is also associated with that? So I have a solution for going forward, which is what this session is about, because part of the problem with lawyers in Europe is that we have been regulated by generalization. I would go further and say regulated by slur, and the slur is professional enabler. And this has happened in money laundering, where all of lawyers are regulated now across Europe by money laundering, part of which involves a breach of professional confidentiality. As the previous speaker mentioned, we do have to whistleblow on our clients if they're suspicious transactions. But my point is this, and here I'm coming to the point of what I'm saying. There is a mass of regulation to try to avoid money laundering in Europe. There is no evidence as to whether this is actually working. In fact, there is evidence it is not working, despite the huge regulation on lawyers. So the classic example, of course, is the London property market, where the National Crime Assessment in the UK continued to say last year that it's a mass depository of billionaires' funds, ill-gotten gains from countries abroad. Somebody is doing the real estate transactions here. Presumably they're lawyers. Who are they? Nobody knows. How is it happening despite all this regulation? Nobody knows. So my solution is this. We know nothing about how this is all happening and why, despite regulation, there continues to be this kind of activity among lawyers, which is all I'm concerned with. So, for instance, America and Canada does not have this kind of money laundering regulation with tipping off of your clients and a whole battery of duties on lawyers. Is the money laundering by lawyers less, through lawyers, not by lawyers, through lawyers, less in those countries compared to Europe? Who knows? Has anybody done the research? I'm not aware. I'd be very interested to know. It's who's doing this in the London property market? How come it's still continuing despite really severe money laundering regulations on lawyers? Who knows? There's no research. So my solution is we need to have policy making by research and evidence, not by generalization and slur. And that is the direction in which I would like us to go. Thank you.
Thank you. All right, Henry.
Yeah, so we heard in the initial panel a lot of cases and heard about a lot of the bad actors, and then in the second panel, more along the lines of ethical issues. And like attorneys, CPAs are held to confidential client information rules. And, this is clearly an issue that is global in scope, and various bodies have undertaken it. The G20 has looked at tax planning from an aggressive standpoint. And the International Federation of Accountants currently is contemplating a project to incorporate some rules around tax planning into its code of professional conduct. And the AICPA and other global membership bodies who regulate and or have professional accountants in them, whether they're in business or in public practice, adhere to these ethical standards. The challenge is defining it in different jurisdictions. Just the term aggressive tax planning, there's limited negative connotation to that term associated in the US. But in the UK and Europe, it does have negative connotations. And that's one of the challenges in trying to develop these standards on a global basis, that we have different rules in different jurisdictions. And we talked about the various firms, and even though the larger firms are all independently owned, they all obviously work together, but are held to different standards in their different countries of residence. So, from the standpoint of trying to find a solution, I think we can continue to pursue various ways to educate the public and educate the professionals and hold them to standards, but it's incredibly difficult for individuals to adhere to a common standard just because of the fact that there are different rules and regulations in various jurisdictions.
Thank you. Paul.
Thanks. I enjoyed the discussions earlier, and was struck by the discussion about ethics. I used to be at the Department of Justice and have been in private practice for a long period of time now, doing whistleblower cases, and it's almost not part of the discussion. It's all about sort of calculation of risk that people are going through when making decisions about whether to commit fraud. And so in listening to that discussion, I'm reminded of the need to socialize people and to have education and instruction across the board, of course, for including, probably most importantly, for professionals as the initial step in attempting to deter this kind of conduct and encourage lawfulness. But I think the reality is, and certainly that's been my experience, there will always be immoral behavior. And so with those folks, you need to alter their calculation of risk. And obviously sanctions for disobeying the law are important, but they also have to be concerned about actually being caught. And that's where whistleblowing is so instrumental. In my view, having done this a long time, that is the most profound change you can make in attempting to encourage and actually apprehend unlawful behavior. I was at the Department of Justice in 1989 through 95, and just before I joined the civil fraud section there, the False Claims Act had been amended to basically ensure that whistleblowers would be able to obtain a recovery if they were successful in their claims against those who were defrauding the government. The section that I was in had previously just been relying on government investigators and the normal sort of law enforcement avenues to try and deter fraud against the government. And the collections were running at about 29 million a year, I think, in '86 when the statute was amended. And of course, it's well documented now that recoveries are in the billions of dollars each year. And that's because of whistleblowing. I mean, it has had an absolutely tectonic effect. And it's why the IRS and the SEC and the CFTC in other countries and many states have embraced this same idea. And folks have, I think, recognized that in some of the comments that were made in the earlier panels. But I think it might be helpful to just articulate some of the things that can be done if you believe that this is actually helping. What is it exactly that you need to do to get whistleblowers to assist you in deterring and apprehending immoral behavior, the violation of law by folks? And really, they're pretty simple. First of all, you have to guarantee rewards. People are making a decision to take a great deal of risk. And if you don't properly incentivize them, even though they may have some moral objection, their personal calculus as to what's in their best interest might not lead them to come forward. If you give them a guaranteed reward, then they will come forward. And that is what you saw in the Department of Justice's program. You've seen the same thing with the SEC, which has now had $2.5 billion in recoveries based on whistleblower claims since that program was initiated. I used to do IRS whistleblower work before they had a program that guaranteed people recoveries, and there was a trickle of work. But once the IRS passed a statute that guaranteed rewards, had people coming in with hard drives of data from offshore bank accounts and so forth, with trying to do what they could to, first of all, do what they thought was the right thing, but also obviously obtain a reward. Another thing that has been prominent in the discussion is the protection for whistleblowers. There is a risk of being blackballed and retaliated against. I think folks would come forward either way in many instances, whether those protections exist or not, because they don't place that much faith in them. But they do discourage retaliation by the companies that are engaged in fraud. And then the last thing I would add is there needs to be an active role for folks in enforcement. That was mentioned before by Charlie, I think, about how he was kept at bay by the IRS due to our Internal Revenue Code. Well, the Internal Revenue Code of the United States basically prevents the IRS from sharing information about people's tax returns with folks outside the service. You can share that information if you get a 6103N contract with the IRS, but they've never done it. And so that has really limited the IRS program. And if you look at the recoveries under that program relative to the others, they're diminished as a consequence of not taking advantage of the resources that folks have to offer. Also, you can't actually just prosecute a case on behalf of the IRS like you can under the False Claims Act. You can't take over and basically litigate the case yourself. In New York, you can, and that's a profound difference and is leading to the success of that program. Many of us have been arguing for qui tam for tax for many years, but that is a hugely important aspect, because it's one thing to bring the government information, it's wholly another for something to be done about it. So if you can allow folks to bring private resources properly incentivized to actually enforce the law, that is the kind of change, that is the kind of profound change that I think that folks are after, and will allow not just recovery against those who've already committed fraud, but deter further misconduct as well.
Thank you. Frederica.
Good afternoon. At least it's afternoon here. It's a pleasure to be on the panel with my colleagues from around the world and with the other panelists who've spoken today. I just want to put a little bit of context around what I'm going to say, because my expertise, such as it is not in tax, area of tax specifically. What I work on is anti-money laundering initiatives by the regulators in Canada of the legal profession. But I think there's a great deal of, I think there are issues that resonate, that cross over, and whether it's tax evasion, or whether it's predicate offenses, other predicate offenses involved in money laundering, I think isn't all that central to what I have to contribute. First thing I want to say, and Jonathan and I share some common ground on some of these issues, but the first thing I want to say is, the language of professional enablers, when it is used to talk about entire professions, is unhelpful. It is alienating. It alienates people who are deeply committed to the same things that everybody else who's been speaking today are committed to. And I've been struggling to find better language. I wasn't very happy with gatekeepers either when that was the norm. And now we seem to be talking about professional enablers. So I want to put that out there because words do matter, and it does matter if you alienate the members of the profession who you have an opportunity to reach about these issues. And that takes me to one of the main points I want to make today. And I was very taken by much of what Daniel was saying on the previous panel in some regards, having both worked, so the organization I work for is an umbrella organization of the regulators, of lawyers in Canada. So I don't regulate anybody, but I spend a lot of time thinking about regulation, working in that area. And I've also had the privilege of teaching legal ethics in law school here. And I've thought a lot about the emphasis that we put, where we put the emphasis when we talk about professional responsibilities to lawyers. We talk a lot about the duties that we owe to our clients. We talk a lot about, and for lots of good reasons. I'm not saying that this is all wrong, but to my point, we talk a lot about the duties of confidentiality, duties of competence, a variety of duties as an advocate, and so forth. And we weave in duties to the administration of justice. But much like there's a sort of, you may think I'm crazy, but I think there's a sort of a commonality with the way we're talking, at least here in Canada, and I imagine you're having the same conversations in other countries, about the pandemic and vaccinations. So allow me just to say this. We are focused on rights and not responsibilities a lot of the time. And I am a deep believer in individual rights, but they must exist in a broader social context in which we also have responsibilities. So coming back to the legal profession, in teaching young students, what I observe is they very quickly grasp their duties to their clients. They understand that they owe a duty of commitment to the client's cause. They understand that they owe a duty of confidentiality, even if they don't always understand how to honor it. They understand those things, but they don't, there's a tendency, I think, as a result, to over-identify with the clients, to move away from thinking of yourself as a legal professional and think of yourself as a servant of the client. And there's a relationship, but they're not identical, right? Because of course, as lawyers, we have broader responsibilities. That's my point about the need to focus on those broader responsibilities, the need to understand that those duties to the client exist in a context where we have duties to uphold an entire system of justice. We have duties to that I think, some of which, I don't want to get into a philosophical debate, but I do think have their roots in morality and ethical matters. And they're not always the same. Common morality, you'd tell if you knew something that could save somebody from getting hurt. And that's not really the morality of the legal profession. But in spite of those exceptions, there is a sort of a question of morality that I think is important in the practice of law, and I don't think it is emphasized enough. So in the legal ethics instruction that I have most admired, seen taught and most admired, is instruction that helps students to develop a reflective approach to ethical issues, to practice generally into ethical issues, so that they learn to identify when there are problems. That, to me, that's part of the solution. And it sounds so basic. Well, how do you not know there's a problem? But when you consider that tremendous emphasis on identifying with the interests of your client, you need also some guidance in understanding where your client wants to go someplace that you cannot help them go. You simply cannot. And the rules are quite clear. The rules in Canada are the same, essentially, as the rules of the American Bar Association. You completely prohibited to assist a client in committing any kind of criminal act. Certainly, tax evasion would be there. would be amongst them. But you need to understand where those lines are, where you're headed that way, where you're headed in that direction, and what you do about it. And I think that it's only recently in Canada that legal ethics is a mandatory course in law school. I think that is an important aspect. I also think that another related aspect, and really I guess my theme is a bit about education, because it is what we're focusing on, and it is in the money laundering area, but I think really it's about helping members of the profession to develop a combination of tools and instincts to identify problematic situations with their clients. We do in Canada, although we are not subject, the legal profession in Canada, as a result of a constitutional challenge which we brought, we are not subject to our government's anti-money laundering regulation. But we looked at this and said we have to take this on. And I've seen some comments in the chat about self-regulation, and I'm familiar with the criticisms. And it's not a perfect system, but it's also not quite as imperfect as many people would believe. In Canada, at least, the regulators here are becoming zealous about the enforcement of regulations which are designed to mitigate the risk that lawyers will become involved in money laundering in particular, but illegal conduct in general. And what we've learned is that a lot of lawyers, there's a combination, right? Spectrum was talked about earlier. You have the people, there was a reference to people sort of passive and active involvement. And I would say you have the committed criminals. They're mercifully a small number in most professions, including law, but you have some. We have the willfully blind, not really paying attention, don't want to ask too many questions. And you have the people who properly equipped, and I do think that this, if properly equipped, this is the majority in the profession, who they need help in learning to identify those situations, but once identified, they understand where their professional responsibilities lie and are not going to assist. So that educational piece has to be broad. It has to help people. We've focused a lot on educating the profession about why money laundering is such a big problem, why it is not a victimless crime, why we need to care about it as legal professionals. What are the contexts in which we might get drawn into it as lawyers? And what does that look like? What are the red flags? How do we address that? And spent less time on, and the rules say you must do this, and then you must do that, and then you must check that box, and you must keep that document. And by focusing on that educational piece, I think we have a greater chance, when combined with hopefully getting the students younger, really learning to be reflective about their ethical obligations, their professional obligations. I think that's really the way forward in terms of changing the role of lawyers. And I know I'm running out of time, but I do want to make one point that I can come back to later, and that is we're talking about systemic issues. So I've been talking a bit about what I consider some systemic issues related to the legal profession itself and the education of lawyers. But there's a broader systemic problem, and that is, so in Canada, for example, our government's anti-money laundering regulations require all people who have to report to inquire into beneficial ownership. Canada is known as a country that fosters opaqueness. It is a matter of public policy that we protect the identity of corporate owners. So, I'll look at these two, obligations, or sort of the obligation here on those who must report, and public policy over here. Now it's changing. We're moving forward to have somewhat greater transparency, but that is a policy which prioritizes certain economic interests. Those who believe that it's important will tell you that it's necessary for investment in our economy, and that it is important that anonymity be provided, and so on. And those broader public policy issues must be addressed if we're to get a handle on things like money laundering or tax evasion, because there are incentives, to the comments both from some of the people writing questions and some of the panelists before. There are incentives built into the economic and political systems around the world it's sort of things that contribute to the facility with which these crimes are committed are sometimes matters of public policy, and that needs to be addressed. It's not simply a matter of saying, the professionals must do this or that, or we have to crack down on professionals.
Thank you. And Simone.
Thank you for inviting me in such a challenging discussion. I want to focus on two main issues that I have been taken from the discussion they had before. And one is that's maybe a consequence of my civil law perspective. It's that we have to draw borders because we cannot speak about fraud, tax evasion, tax avoidance as all the same ethic, moral, and criminal issue. A lawyer, when we know what is a fraud, when we know what is a crime, a lawyer that commits or help committing that crime is not a rotten apple in the good basket. It belongs to another different basket. You're committing a crime if you do give advice on how to commit a fraud or a tax evasion, whether you're dressing or not a lawyer's robe. It is a totally different work. What we have to focus is maybe on the gray areas that are just across the border of what is a criminal offense. And my country, unfortunately, is maybe one of the most complicated country in complicating law in tax. Our gray area is very, very, very thick. There is no 50. There is 50,000 shades of gray in tax law in Italy, and that helps, of course, tax evasion. That helps tax elusive behaviors. What we have and what was maybe a solution, and it's a common background in individual professional responsibility. We have professional bodies that still have power against those who put themselves out of what is lawful by revoking the license to do the accounts, to do the lawyers. We have still an approach which is regulatory and individual. Laws and regulation of the profession and individual responsibility. There was a question that was put before, how hard it is to say no to some bad conduct. It came to me another question. How easy is to say yes to such conduct when you live in a firm where you don't have even a desk, not even a desk, you only have a closet, when nobody really takes the decision and everybody can hide behind the shell of this big law firm, maybe a limited partnership, maybe a company, a legal entity that gives shelter to those conducts. So maybe one of the solution I can bring from a civil law country which has problem with the gray area is to focus on the individual responsibility of the professionals and giving the professional body, giving back if they don't have, giving back the power to discipline what is wrong and what is not wrong. I mean, it's not only the prosecution service that can do that. There should be another way of preventing it. If you get your license revoked to do advice, to do your job, maybe you don't need to go in front of a jury or to have other things. I think that the European system from that point of view has given until the big firm came has given a good prevention of the bad apples start making their own basket. This is one of the issues that, as you know, passed through my mind after asking that, because in our tradition, you know, never had big firms, we never had employees, professional employees, and we never had this kind of problem. And what I can say is that we are trying in Italy to have a proper whistleblower regime. We are at the very first steps, and after what I heard, I have to say that we are, if after all these years you still have your issues with whistleblowing protection, we have a long way and long time before getting to good results. Thank you. That's for my first.
Great, thank you. So what I thought I would do now is just kind of have us collectively focus on sort of a series of kind of step-by-step questions. They really build on different points that each of you have raised, but I thought we could kind of collectively sort of build that out. And so the first is one that ran through many of your remarks, which is ethics. Sort of the role of the professional organizations in sort of establishing their own ethics guidelines, and sort of the degree to which that was a strength, but also maybe sort of inadequate or not fully up to the task of addressing our concerns here. And so I guess the question I would put to you is, if you think about the sort of industry guidelines, so whether you're thinking of the CPAs or lawyers, your own sorts of codes of ethics, codes of conduct, that are not, in a sense, necessarily, they may be optional. That was mentioned at one point. What do you see as the strength of those codes and their weaknesses as it relates to the kind of questions and problems that we're looking at today? So if anybody wants to jump in on that. Yeah,
sure, I can jump in. With respect to the rules of ethics that govern attorneys in the United States, there is a crime fraud exception that permits a lawyer to disclose communications with a client that were aimed at committing a future crime or fraud. You're not allowed to disclose revelations of past criminal conduct generally, but you can disclose a future crime or fraud. So if you wanted to do more on that front, and I think that there are reasonable arguments to be made in that regard, you could also permit disclosure to rectify a crime or fraud when the attorney's services were used to accomplish the crime or fraud. You may want to go further and not just make it an option for the attorney, but make the reporting mandatory. I think that it would be a dicey matter at times, obviously, because an attorney is trying to assess whether or not their own client is criminally responsible and they're paying the bills, and it's a difficult decision, I'm sure. But if the threshold is high enough in terms of the evidence of the crime that has been committed with the assistance of the attorney, or the fraud or crime that was about to be committed by the client, making reporting mandatory in that context would certainly help with enforcement. I think that there would be a concern relative to, whether or not clients would be willing to, fully, communicate with their counsel if this risk existed. But I think that what you would probably see is most folks who are trying to obey the law would continue to communicate with their counsel, and folks who are looking to evade the law would be more circumspect about their use of attorneys to assist them. And so if you're trying to deal with professional enablers, which I recognize is a narrow, sort of group of folks within the profession, those things might help.
Jonathan.
I would like to comment on that. I mean, I think part of the problem with changing rules in this is if the regulators aren't making the rules, who is making the rules? Because often in this case, particularly if we're talking about tax, the government is on the other side, and part of the rule of law should be that the government should not be regulating lawyers when they may be often be on the other side of a case. So I'd be very careful about going down that route. We have in Europe, I know in the United States, the lawyers are regulated by the courts, and that is a very good solution, a good independent solution. The previous speaker was talking about getting lawyers to disclose. Really, you heard from Frederica in Canada, the Supreme Court there said that that was in breach of the rule of law. She will give the correct wording. And we would argue in Europe, even though lawyers are bound to do it, that it really breaches fundamental rights. Somebody put in the comments about this is not the solution is not in regulation of lawyers in our case, but is in whistleblowing and encouraging whistleblowing. And I must say, I would certainly rather go along those lines rather than see. In my view, the regulation of lawyers using money laundering is the classic example. I realize we also do about tax crime, has not worked and does not work. And I would agree that other solutions need to be found. Thank you.
Linda, did you want to jump in? You started before.
Well, yes, thank you. I was actually going in a slightly different direction. You were sort of talking about what some of the, asking about what some of the strengths were as well as the weaknesses. You know, first of all, I think we all should have an ethics professor who does what, you know, Frederica describes that she does with her students. I think as Diane knows, because I've done a fair amount of ethics speaking with Diane, I do a fair amount of ethics speaking to the profession. One of the good things that we have in the United States at this point is I think the bars of every state, or virtually every state, now require continuing legal education specifically in ethics. And I think an awful lot of lawyers view that as kind of being you know, oh, that's a pain in the neck, or at a CLE program that may go 7 or 8 hours over the course of a day, they'll put ethics last, and lo and behold, there's a smaller attendance at that session. And one of the things that Diane and I get a kick out of, I think, is making it so entertaining that people are really looking forward to that program, or come back and say, well, I'm glad I stayed for that one. It was really interesting, and it was entertaining, and it was provocative, and all that other stuff. But I do think that there is a real value in law school, and I don't think it's done that often, where I think the focus on ethical training for lawyers, at least in the United States, is on a lot of the rules that apply when you're in a criminal defense context, and what if your client is going to commit perjury or has committed perjury, or what can you can you communicate with unrepresented parties on the other side, and various conflicts of interest, that sort of thing, which are all very important. And also escrowed funds is a big issue that people talk about, but they don't talk about things like this, which is when you have a set of rules or regulations, and when you have a client who you perceive as pushing up against those rules or regulations, or even going just over, not clearly this is fraudulent, clearly this is criminal, that's an easier case, but where you're kind of right at that line, or in those shades of gray that Simone was talking about. What should the lawyer be thinking? What should the lawyer do? What should the lawyer say to his or her client? When should the lawyer withdraw? When should the lawyer encourage a client to do something different, and so on and so forth? And those are really important in the context of what we're talking about here, because it's not something that's so obvious that you can test on it on a multiple choice bar exam. It's actually a very subtle but very important thing for lawyers to think about. And I think the group who has certainly spoken today, and many of the comments, people are participants I see in many of the comments, this is a group that's particularly sensitive to these issues. So many of us have thought about these issues in whatever profession we're engaged in. But I think there's a real challenge to sharing that more broadly and not simply to say, okay, in the United States, if it's a CLE, continuing legal education program, we're going to talk about ethics. You know, what do the regulations governing lawyers in Circular 230, which is our, you know, regulation from the government, or basic stuff say? But actually, let's talk about in context. Here's a problem. Here's a factual pattern that could happen in your practice. Not what's the answer, but what's the thought process that you should be going through given whatever authorities there are. And I think that's an important part of this also.
Henry, did you want to?
Yeah, first off, I can attest to the fact that Diane and Linda's presentations on ethics are always entertaining, having sat through a few of them. But the challenge, and to support Linda's mentioning the CLE requirements, CPAs also have continuing education requirements, and I believe 49 of the 50 states, I think Georgia is the only state now that doesn't require some sort of annual ethics training for licensed CPAs. But within the AICPA code that I mentioned earlier about the International Federation of Accountants, and they've adopted a provision in their code with the acronym NOCLAR, which is non-compliance with laws and regulations. And due to the client confidentiality issues that accountants face, and the need to protect that client confidentiality, currently the AICPA code does not currently provide specific guidance for members who encounter those type of situations, whether they're actual or specific. And our Professional Ethics Executive Committee has exposed some revisions to our Code of Professional Conduct, seeking comment on them, saying that the public interest is best served with the inclusion of robust guidance in these interpretation, which sets forth a member's responsibilities when they encounter that type of situation. But it is clearly challenging from the accountant's perspective, because they have to adhere to the client confidentiality rules with certain limited exceptions.
If I could just add very briefly to the topic, because I know we've spent quite a lot of time on it. I just want to say that in Canada, codes of conduct are not voluntary; they're enforceable against lawyers. Lawyers are used to prosecute lawyers for unprofessional conduct in every jurisdiction. So I just want to make that clear, because I think that is important in terms of their value and whether they provide value. They do also provide guidance, to the point that was just made. There is a lot of, in our codes in Canada, based on the model code the Federation has produced, there's a lot of guidance in the documents as well, but there are enforceable rules. The other thing I wanted to speak to just briefly was Paul's comment at the beginning about exceptions based on future harm or on harm more broadly. In our code, we have mandatory disclosure, rule on mandatory disclosure for death, where there's a reasonable prospect of death or serious bodily injury. We do not have an exception for fraud, crime, and we do not have an exception, which we did consider, and I think we'll come back one day to sort of financial harm, specifically financial harm. But I think those ideas, although they are difficult with the profession, you know, one of the reasons in Canada, it's solicitor-client privilege, which has been very, very robustly enforced by our Supreme Court as an essential pillar of the system of justice. And the rationale is based on that need to make that full disclosure, to Paul's point about what people might tell their clients after, to make that full disclosure to their lawyers to get good legal advice. But there are other issues at play that are important to consider. I think they're very limited. I think that one can interfere with the duty of confidentiality or with solicitor-client privilege only in very limited circumstances, extremely limited. I do believe that the rule that requires disclosure to prevent death or serious bodily harm is a correct rule. It's not antithetical to the basic ethical obligation. But the further we go from things that everybody would agree are so heinous that we must prevent them, the more complex it becomes. I don't think, however, that we should shy away from at least having those conversations. So in answer to the question about what we might, where are their weaknesses, I don't know if it's a weakness in the codes of conduct that we don't have more circumstances in which there can be disclosure of confidential information. But I think it would be valuable to continue to talk about those issues and to consider how we balance the very important duties that lawyers owe to their clients because of the system of justice with other very important matters that are important to our entire society. It's not a popular view necessarily amongst lawyers, but I do think it's important to continue to have those conversations.
Thank you. So we're closing out on our time, but there were just two topics that really have been running through the session so far that I just kind of wanted to surface again here and give you a chance to comment on. The first is, revolving door. And it really kind of can be a question in at least two ways. One is thinking about it in terms of the design of substantive rules themselves. And we've heard a lot about sort of tax fraud, tax crime, and then that space that shades into gray, right? And so, there's ways in which revolving doors may play into that, may play into enforcement, may play into the regulation of the practice itself. And so just kind of wanted to lay that out there. We don't have too much time, but if you had one or two thoughts you wanted to raise on that, it'd be wonderful to hear them.
I'll chime in, having revolved out the door myself. I took, it was interesting to hear, I think it was Mr. Dugan's comments relative to, he took exception to the notion that former government personnel, were, going to be biased by, their future prospects. And I know certainly when I was at the Department of Justice, I don't think I've worked with a group of people that are more ethical and, people I respect more, and or were as capable. So I was, agreeing with much of that. But the reality is, I also know that in pursuing cases involving fraud, when agency personnel's next career move is naturally to the precise industry that you're pursuing in a case like the defense industry, or in the case of the IRS, it's often to defend taxpayers. That does present a problem. I mean, you just have to look at comments by the former commissioner of the IRS, Don Korb, who said, I think he was chief counsel. He said that he thought that the tax whistleblower program was a disaster, and that it would have neighbors reporting neighbors, and was very antagonistic toward it. And naturally, he was gonna go and represent taxpayers after he left the government. So I do worry about those kinds of revolving door concerns. I think they're real.
All right. I'm just going to jump ahead to the other question now, because we are almost essentially past time, but just have a few great things we want to say. Whistleblowing, right? That has been running through all of this. And, we've talked about, even in this panel, Paul, you've mentioned, the possibility of key TAMs at the federal level, have seen at the state, what a difference it may make. We've talked about governments engaging with the whistleblower, more resources for governments to pursue information brought in by whistleblowers. And as well as sort of what kinds of recoveries there could be or protections for whistleblowers. What I wanted to do just in this last round of question is if there's sort of one specific change or element of a whistleblower program that you think would be essential, a change that should be made, something that's not sufficiently done differently, what might that be? Henry.
I'm not sure if I could answer that question to a point where there's one thing that needs to change. I think whistleblowers need to be supported and be given the protection that they deserve. I don't think that exists right now. And people, as we've heard, people are taking a major risk to their career and to their personal well-being, whether individually or that of their family, if they do start to walk down that road. And I think that that's what keeps many people from doing that.
All right. Then at this point, we had promised those of our prior panels who hung on to the bitter end, and it indeed is the bitter end, that they would have an opportunity to sort of offer any comment or question or remark. And so for those who are remaining, if you have such a question or comment, now would be the time to turn on your mic, turn on your video, and comment away.
Can I make a comment?
Yep.
It's Simon Bowers here from Finance Uncovered. I was just very intrigued at this idea that lawyers as a profession were being smeared. And I mean, I do think there is a problem in grouping people and talking about them as enablers, but I'm not sure if there's also a risk of making an exceptionalism argument around lawyers. You know, there are lots of great accountants out there too, lots of other professionals who are you know, very ethical people. But you know, I don't want to go into the specifics, but I was working on a story recently where you know, I was looking at leaked emails of a lawyer advising a company, and it was clear in the back and forth that the lawyer, this was a real blue chip law firm. It was clear the lawyer knew that the company wanted to pay a bribe, but needed to wrap it in a presentational bow that it wouldn't be perceived as it wouldn't trip over the FCPA rules. And the lawyer, there were 3 law firms involved, and they all like danced around the client. They knew what the client wanted to do, and you know, they flexed their ethics or whatever. You know, they were motivated, as we all are, in you know, paying the bills and winning the client's business. And so, yeah, I just make that point.
Thank you. Charles, you?
Yeah, I mean, I would further that point. I mean, I think the professions have been roundly smeared with the truth, right? I mean, I was a practicing lawyer, and we backdated documents. That was done, right? You know, you don't say we're backdating the documents. You say to your client, "Did you agree to this earlier? When did you agree to it? Okay, we're dating it as of that document." Look at any due diligence file and see how many documents say as of such and such a date. It's not necessarily backdating, probably is, right? The professions have, and I think that the bottom line is people want to be ethical. People want to do the right thing. What people really want to do is feed their kids, pay for their BMW, send their kids to private schools, live in the right neighborhood, right? And the consequences matter much more than vague terms like ethics and public policy and, you know, morality. It's, you know, this is the most overused, you know, analogy in the history of analogies. But I mean, the people in Nazi Germany who were persecuting the Jews were good people, right? They didn't kick the dog. Right? The founding fathers of the United States were good people. They just happened to own slaves, right? People are moral relativists every single time. And that applies right now, and it applies to the lawyers and the accountants. If you work for a major accounting firm that's auditing a company that's committing fraud, and you don't understand your client well enough to recognize that they're committing fraud, you're an idiot. And you're not an idiot, right? You know it. You're dancing around it. You're doing what it takes to get through the day. So I think that focusing on, rules, like there's a lawyer rule that says you can't tell a lie. It's hard. I'm sorry, I couldn't keep a straight face when I said it, right? Because lawyers have to lie as part of their job. CEOs have to lie as part of their job. The translation for "we are not engaged in merger negotiations with that company" is "we are engaged with the merger negotiations with that company," right? Every single time, right? A month later, yes, we are, right? So I think that expecting people to live up to unrealistic standards and then complaining that those standards are too vague or whatever is a nonsense endeavor, right? The right answer is incentivize people to do the right thing, and that's all about whistleblowers. Capitalism is a most effective tool that we have figured out yet for allocating resources. It gets things done. So use capitalism to fix the problem. There's tens of thousands of professionals, and they would just as soon tell the truth as not. Incentivize them to do so, and they will. Disincentivize them to tell the truth, and they will not tell the truth. It is simply that simple. I mean, I'd love to hear any of the defenders of the professions that have been on this panel jump in and say, no, it's not that simple. I mean, please.
All right, Jonathan, did you turn on for that, or?
I did. I want to reply to both those points, and I'm very pleased to have got that kind of blowback, because I think the previous discussion was too much in one direction. I'm glad I put down a marker. I agree with nearly everything that I think was Simon who said, some of what Charles has just said. My only plea is for targeted responses, not generalized responses. That was really what I was saying, because I don't think generalized responses will work. I agree with some of what Charles said. I agree about whistleblowers. I don't. I think that, well, we would that change and backed by evidence and research. I support it.
Thank you. All right, so I have in my final queue, Mary. I assume Mary, because you popped up, and Daniel, and then Simone. So Mary,
thanks. I think I wanted to sort of add to the comments about you asked a good question about what would be your wish list for an effective whistleblowing program. And I think we talked about it earlier in the day, but I think it bears repeating that I think we have a long way to go in the United States, at least, that I think there are 31 states that have false claims acts that are similar to the Federal False Claims Act, which empowers whistleblowers to launch lawsuits in the government's name. I think we've seen California, recently DC actually adopted a similar program to the New York False Claims Act, which actually lets whistleblowers, most statutes have exceptions saying you can expose all sorts of fraud against the government except tax fraud. And New York has fixed that. DC has fixed that. We'd very much like to see the other states who already have False Claims Act. It's not a large leap to get there. But I think part of the issue is that for reward programs to work anywhere, right? Canada has one. South Korea has one. The regulator has to take action, because a reward is a percentage of whatever fine is imposed. So I think that retaliation protection is not enough. Empowering whistleblowers to give tips or launch lawsuits is a really vital part of it, but it really comes down to how aggressive a regulator will be. The SEC program has done phenomenally well because it's persuaded whistleblowers that they are being aggressive. So I think my wish for a whistleblower reward program would be a really strong regulator, tax regulator.
Thank you. Daniel, did you have a remark?
Okay, I'll throw in a remark. My remark is that if Charles's primary point that Jonathan and Simone seem to be on board with is that people like money, I fully agree with that. Are people engaged in can people engage in self-restraint and not take every last dime if it causes too much harm to others? I think that also is an a priori obvious statement. So all I'm asking people to do is to reflect on where you're going to draw the line. And I don't see how you could possibly disagree with that. I would also point out that who I teach is I teach at a business school. So my students are all MBA students. I'm not teaching lawyers, and I do executive ed. So I meet with mid-level executives and talk about ethics with them. So that's my particular audience. So when you're saying, am I trying to focus on professions? I don't know. As an executive of profession, I suppose it is. As business of profession, well, Louis Brandeis said it was. I don't know if it really is. But it seems to me that reflection upon values and reflection upon ethics and asking people to engage in conversations like Linda and Diane obviously do, whether you're doing it with lawyers or whether you're doing it with business people, is a worthwhile endeavor. And for AACSB accreditation in a business school today in the United States, you have to teach business ethics as a requirement. It goes back to the Pinto scandal. So not only do lawyers get ethics training, so do business students, and trying to get business students over the hurdle of the only thing that matters is shareholder returns is really tough, because everybody thinks that's all there is to business is the corporate bottom line, and so it's tough sledding. But I think that there is an argument on the counter on that, and that's what I tried to share and I think about in my writing and share with my students. But that's a comment.
Diane, I would add just quickly to Daniel's point that I do think we are starting to see companies, the SEC has made it an enforcement priority to go after ESG issues. So I think we're evolving more than just looking at returns, but now socially conscious investors, it's material if you are greenwashing. So I feel like we're starting to step more into that venue, which I think is a positive sign, where business school students have to know that you have to deliver more than returns for your investors. For some investors, you have to have an climate focused policy.
Great. Simone. You're muted.
Yes, all right. Sorry if I come back to the revolving doors, but I had to think in English what I was thinking about. And it goes like that. If a revolving door is a problem, because people just, turn the jacket or change the jacket and do opposite thing, that is a proof of how deep is the problem of ethics and moral, because it's not a question of persons. Because the same person, if he works for the law enforcement, does something, and if he goes in the private sector, do the exact opposite. Revolving door should be, in the best word, something that should be useful in sharing and bringing your own moral and ethical standards in the private sector. If it is a problem, if it is an issue, that means that the basics are not shared in neither the public or the private sector. And this is something I wanted to say, and I am sorry that I spoke after Professor Ostas of Ethics and Moral, and I don't really wanted to say something about that after what he said. I totally agree with him. Thank you.
Thank you very much. I know actually we could go on. I know a number of you have some excellent additional points to bring to this, but I think we have truly hit our time. It seemed, there was some flexibility, and then there just comes a point. So I just wanted to kind of pull together the threads of what I think came out of this conversation. It's not a solution. It's not even any kind of definitive direction of a solution, but I think some things that really have been clearly emerging. So the first is that that line between sort of tax evasion and fraud on the one side and everything else is really important for our conversation, because it is a gray space that seems to be inevitable. That conversation about accounting and law, which one's more bright line? In fact, neither. I mean, it is inevitable, but especially with the complexity. And there are questions about to what degree do the professions contribute to that complexity, and how do we think through that? And that kind of brings me to sort of the power and limits of ethics. I think we had some differing views. I don't think anyone thinks ethics aren't important. Maybe some differing views about how much we can rely on them, how we can best bring them to bear. But that certainly is really, I think, the sort of intersection of those shades of gray and ethics are going to be a challenge. The next thread that came running through was, how people make decisions, right? And the real pressure between the incentives, money, job, right? If I'm a business, market share. On the other hand, the risks of doing certain acts that might be otherwise not desirable, and sort of what that balance looks like at any moment in time in any country, sector, or profession. Right? The reliance on and the role of whistleblowers, right? That's pervasive through everything we've talked about. I think there's been an interesting discussion about the systemic dimensions of this problem. And I had mentioned this a little bit earlier when I said, it's sort of bad apple, bad orchard, right? And again, I don't think there's a uniform view on that. But it is important to think about to what degree we think there are systemic pieces, maybe not the entire problem, but systemic pieces. And those systemic pieces may include the government. And I think that was a point that Frederica was making about transparency in a country. It may be in the business world, it may be in the professions themselves. And then finally, just sort of thinking about the roles of liability. And this was something that we never had a chance to touch on extensively in any of the panels, but first popped up in the original panel and even came up just now. The extent to which professionals may be organized now in, forms such as limited liability partnerships that essentially shield them from substantial liability, and what role does that play in decision making? So with that, it's just kind of a quick rundown of some major thoughts you've all offered. I would really like to thank our panelists on this last session who have stayed and enjoyed the entire program, but really offered their thoughts now, as well as those who came back to join us for the last bit. And Costa, I will turn it over to you.
Thank you very much. Thank you, Diane, for your brilliant moderation of not one, but two panels. So that was amazing. Thank you to all our panelists. They were, it was a fascinating and rich discussion, and we will surely integrate all the elements that emerged, the fantastic discussion into our reports for the project. So thank you so much also to all the attendees. There are still 22 attendees here with us. Thank you very much. And I stop the recording now.